Do you want to come in on that?
Well, just picking up from, if I'm hearing correctly, Mr. Inglesi, what you've accepted is 2 points. Firstly, that you accept HMRC owes a duty to Parliament and to the Public Accounts Committee. That's correct.
I have said that...
You just said it, but
I've said it's part of our functions properly to assist Parliament, and we've taken a view that it's lawful to pass...
No, just please stick to the question. I mean, it even says at page 5 of the 19th of October letter, so this isn't a trick question. HMRC recognises that it is part of its functions properly to assist Parliament. So could we just stick, please, to the questions? I thought you'd already accepted this point.
Yes. Yeah.
Could we just go again? So do you accept that HMRC owes a duty to assist Parliament and the Public Accounts Committee? Yes or no?
Yes.
Good. And do you therefore accept that information can be provided which is non-identifying?
Yes.
Yeah, and I thought that's the 2 points we got to with the Chair. Where does the legislation draw a distinction between identifying and non-identifying information?
Because the legislation looks at each disclosure.
Now, can you refer in the legislation? Where in the legislation is a distinction drawn between identifying and non-identifying? Can you tell me which section that is?
That's the context of the legislation. So
no, it's not. There is no distinction.
18 and 19, and that is the advice that we believe is right, that we've confirmed with First Treasury Counsel. So that is our legal advice, and it's the advice we act on. But
sorry, can I come back to the question? The question: there is no distinction drawn. Can you take me to the section which draws a distinction between identifying and non-identifying information?
It stems from...
Can you take me to the section?
It stems from the notion of what one is disclosing, and so one has to look at each disclosure, and that is the point of the 2011 letter.
No, the 2011 lists 5 policy reasons, Mr. Inglesi, which I will come to and we can go through. Chief amongst those is it having an effect on voluntary compliance. But it does not draw a distinction, the Act does not draw a distinction, on my reading of it, between identifying and non-identifying. So the Department is putting forward 5 policy reasons, which we can come on to, but in law there isn't a distinction, is there?
In law, one has to look at the specific piece of information that is being disclosed.
There is no statutory justification for the distinction, is there? There are policy reasons, perfectly reasonable policy reasons, why you may want to take a decision not to disclose, and we can come on to the policy reasons. The letter from Mr. Hartnett sets out 5 policy reasons, but there's no statutory justification for distinguishing between identifying and non-identifying, is there? In statute.
The sentence, pardon me, the sentence which I read out is the sentence that says that we look at each specific piece of information when it is being disclosed.
So I'm asking for the law. In statute, there is no... Can you take me to where in statute it defines a distinction between the two?
I think the best answer that I can give is that one has to read the whole of this letter to get the context.
The letter is not, with respect to Mr. Inglesi, the letter is not the law. The letter sets out a range of factors which are policy considerations. What I'm asking you is, from a statutory perspective, where in statute does it say? What we've got here is we've got a door, and the door says where there's a gateway, which is, if you have a duty to assist Parliament, you can provide information. And in the case of this committee, the gateway is open. But in statute, there isn't a distinction between those two things. And referring to the letter, it's a totally different issue to what's in statute. Do you accept that in statute there is not a distinction drawn? You're General Counsel, as I understand it, for HMRC.
Yes, I'm the General Counsel.
Yes. So as the General Counsel of the Department, do you accept that in statute there isn't a distinction between identifying and non-identifying information? Yes or no?
looking at the context of the legislation, there is a distinction.
So can you take me to the distinction?
Well, I can take you to it if you would like by looking at the letter.
No, the letter's no good.
It's the Act.
There
is nowhere in law that it distinguishes between those two things, does it? What it is policy consideration. And we can come on to the policy considerations, but in statute you're not prevented from disclosing.
No, it is more than policy.
Where?
Yeah, I think if you have the patience, I must refer you to the parts of the letter which I think are very clear.
Honestly, Mr. English.
The letter.
The criminal offence. I mean, parliamentary privilege applies. The Bill of Rights would apply in terms of criminal offence. And in any event, we haven't gone into the detail with Vodafone, but that's information in the public domain. In any event, I mean that gets us into the issue of the policy decision. I mean, even the letter from Mr. Hartnett. I mean, accepts the point. He says where there is a power to disclose, which is obviously different from the position taken by Sir Gus O'Donnell in the 2009 letter to Edward Lee, where he said we can't disclose much as we would like to do so. He's saying here, where there is a power to disclose, a decision whether or not to disclose must be taken in respect of each identifying piece of information. So there's an acceptance in this letter. And indeed, it talks about the need to reach, in summary, a reasonable decision. So the point is, in law, you're not preventing from disclosing. The point is the department is taking a decision, which it's perfectly entitled to take, a decision at its own discretion as to whether it discloses, and what we then need to establish is whether that decision is being exercised reasonably or not. The point being, you're not prevented in law from disclosing.
As I was saying before to you, there are two levels of this. One is it part of our function to disclose non-identifying, to disclose identifying information, and there the letter says that it doesn't follow that it is properly part of our functions, and the question whether it would be so is far from free of doubt. And because of the potentially criminal context in which the question arises, the department, therefore, it's entirely appropriate for the commissioners to take the view that they don't want to run that down.
You're saying criminal sanctions apply. We're talking about passing information to Parliament. Parliamentary privilege would apply.
It's also necessary to look at the other provisions of the Act that, for example, demonstrate...
No, you're going off onto another point. Your point was criminal sanctions apply. But surely this is covered by privilege.
No, it's important to look at the other provisions because, for example, we comply fully with the NAO. We expose all our papers to the NAO. The NAO have constraints on them, but powers to disclose.
So again, it's a totally different issue. You've no choice over that. The NAO has the right to demand whatever information it has. I mean, we covered that last time. So that's absolutely irrelevant as to how you exercise your discretion. You have no discretion in terms of the NAO. The NAO, by law, can ask for whatever information it requires.
And I know I haven't come on to the second level yet. So the first level, it's entirely proper for the commissioners to take the view that this isn't a function because of the advice.
What isn't a function?
Well, it's here. I've got a
comment on that.
Of the Goldman Sachs one. I mean, it's very interesting. We may come on to as to why you issue proceedings in the county courts, which tends to get less reported than in the High Court, given the value of the sum. But I mean, the documents are here, so they are a matter of public record. As is the data that's in the Vodafone accounts that shows the amount of assets it had.
Content yet. We're still on process.
So again, when it's a policy issue around where you're arguing various sort of policy points around the impact on voluntary compliance or the issue about prosecution of officials. These are policy questions. I'm very happy to spell out why I don't think they apply. But we haven't addressed the starting point, which is the legal position.
If I come on to that level, there's an issue that is set out in the letter that says that if it were the case that a function existed, that function, that power, would then still have to be made in a way that was consistent with both public law principles